Hi, this is Chris German from The Apartment Dealer. Welcome to The Apartment Dealer Show. We're excited for today's show. With us today, we have Mr. Steven Spierer. Steve has been practicing real estate law for over 4 decades now. And in that same amount of time, impressively, has acquired a couple thousand doors when it comes to multifamily. He also has ownership in warehouse, office space, retail. So he has that vast storehouse of knowledge of not only representing landlords like you and in and outside the courtroom, but also being an investor himself. Steve not only owns investment real estate in California, he also owns in Washington, Colorado, Arizona, and has that expertise of dealing with California law, as well as the laws that are outside the state, encompassing it, bringing it together, and to have that fundamental understanding of how do you become a good landlord? What do you do daily to be a good landlord? And how do you profit from your investments? So with that, please help me welcome Mr. Steven Spierer. So Steve, welcome to the show.
Thank you. Good to be here, Chris.
Now, Steve, it has been an interesting 13 months or so. Really began Thursday, March 19th. You and I were together, and we were supposed to have been a part of a live educational event for landlords at large. And in the weeks preceding that, they started cutting back live audiences given the issues with COVID. And so it ended up being a webinar. The subsequent day, March 20th, is when the entire state went on lockdown, March 20th. And then we were on lockdown for several months. And so many things have changed since then. Some of our freedoms are coming back, if I can call them freedoms. And but real estate, I'd like to start out by asking, given all that has taken place, what do you think has fundamentally changed about owning investment real estate?
Well, first of all, thanks for having me. And my heart goes out to the people who have lost loved ones or who've been injured, and for all the businesses that have suffered losses, and in particular for this group, the landlords who suffered losses as a result. What has really changed on a permanent level is nothing. The apartment business is every bit as important as it's ever been. We're going to see some changes in the retail real estate industry, in the industrial real estate industry, because of the acceleration of movement of commerce to the internet. But and of people being able to work remotely. But at the end of the day, everyone needs to put their head down on a pillow. And if they don't own a home, they're going to live in an apartment. And so the apartment business is every bit as viable as it ever was. If anything has changed, the apartment business has gotten better because of rent control, which is limiting construction. It's discouraging competition. It makes it so that people who own apartment buildings and have apartment buildings are going to be in higher demand than ever. Put another way, though well-hearted, well-intended, rent control is going to make worse the housing shortage, which is only going to help apartments. And skilled management is going to be able to navigate rent control properly. So what has really changed? If anything, the apartment business is something better to invest in than it's ever been before.
It sounds like you're very optimistic. I'm optimistic as well. I mean, I just finished rehabbing an apartment building. I'm trying to negotiate a purchase myself right now with, Chris's own capital. But what would you say to those investors that would say, well, Steve, that's all fine and great, supply and demand. But if the government went as far, the state government went as far as to say, you house people for free for X amount of months, and on top of it, we're not going to allow you to evict people, what's to stop them next time, not because of COVID, but because of anything they could dream up, to put that same responsibility on the backs of landlords to create financial distress?
They can't, because landlords mostly don't own their properties free and clear. And there's a cascade effect that would take place if you said landlords cannot collect rent, you just have to house people for nothing. And that is, landlords would be unable to pay lenders. And if lenders can't be paid, then you have a general collapse of the entire economy. There is no possibility that the government would institute that type of draconian measure unless the government had simply taken over the ownership of every business and every piece of property in the country. there's a lot of fear associated with the economy. There's a lot of fear associated with government action. And certainly we need to be vigorous advocates for the things that we believe in terms of governance and what we want government to do and what we don't want them to do. At the same time, saying, well, aside from supply and demand, it'd be like saying, aside from the law of gravity, I could flap my arms and fly. Gravity is going to apply. The law of supply and demand is just as immutable and immovable and reliable as the law of gravity. So the fact is that the breaking point that is brought about by government policy in terms of, let's say, rent control can be seen very evidently in New York, in San Francisco, in the city of Los Angeles, where it doesn't result in good things for poor people. It mainly hurts poor and middle-class people. It benefits the rich. It's completely backwards from what anyone thinks. And when those problems manifest, then ultimately government has to make adjustments, which is what they've done. And they'll continue to make adjustments. They'll try to impose regulations. And then when they fail and they end up with all sorts of problems as a result, they'll make other adjustments, and owning real estate, and in particular apartments, will be a good idea.
Now, with respect to the rent collections, I mentioned that we kind of kicked off the pandemic being together, doing an educational event for landlords. And then in the following months, you and I recorded a few Zoom interviews, walking landlords through some ideas to collect rents, to deal with this eviction moratorium that many were experiencing for the first time. But as we head towards July, and the hope is that the eviction moratorium will finally be lifted, won't be extended once again. What do you suggest landlords do with respect to all the back due rent and those who may still be non-payers come July, if and when this moratorium is lifted?
So a couple of things. First of all, be aware that just because the moratorium is lifted, it doesn't mean that the court system is operating. The court system is currently smashed and broken. If you remember Lucy and Ethel in the chocolate factory with the conveyor belt,
right,
that is how the unlawful detainer system in the courthouse was working when everything was working. Mm-hmm. But once the pandemic hit, you not only had all of the people that no one could keep up with anyway who needed to be evicted, you now had tremendously more people who weren't paying the rent, and the courts were closed. And even when the courts have reopened, they're operating at a fraction of their normal efficiency. The judges and the court system are working hard to bring the courts back online, and they will, but it's going to be months and months. So I don't think I would be jumping at the idea that I can evict everyone once the pandemic is over. But that's not even the best suggestion I have. The position that we've taken in the approximately 2,300 apartment units that we own is, rather than try to evict people, we've put our arms around their shoulders, socially distanced at 6 feet, of course, and have said, look, we're in this together. We'll get through this together. We're not evicting anyone right now. We said this back before there were any moratoria in place. We're not evicting anyone right now. If you can pay the rent, pay the rent. If you can't pay it, don't pay it. If you could pay the rent, but then you won't have money for food, don't pay the rent. If you can't pay all the rent, pay part of the rent. If you pay the rent this month, it doesn't mean you'll pay the rent next month. We chose you to live in our building. You chose us to be the building you want to live in. And when this is all over, we'll still want you here. We assume you'd like to stay. Don't dig an unnecessary hole for yourself. But if you can pay the rent, pay it. You're eventually going to have to pay all of it. But if you have a short-term problem, we're going to approach this in a humanitarian way. I don't think I would change that when the moratorium is lifted. What I would say is that the smaller group of people, tenants, who are taking intentional advantage, those people you'll want to move to evict. And that's the lawyer part of me saying, let's exercise our legal rights and evict those people. because they're not returning calls. They're not in conversation with you. They are employed, but they're not paying the rent, perennially not paying the rent. Those people need to be evicted, and you should evict them. And you will be able to evict people soon. It just won't be quite as soon as everybody hopes.
And I think most landlords have taken the position that you suggested. My team and I talk to at least, say, 100 multifamily landlords a week. And most seem to want to work with those that have truly had a financial setback. But at the same time, those that they know are gaming the system, they see them leave to work and come home from work. They want those people dealt with. They because they want to be dealt a fair hand as well in the whole thing here. Now, let me ask you, as an extension of that, I can only imagine as the moratorium is lifted and as tenant advocacy law groups move in to somehow extend these tenant stays, they're going to be going after the tried and true. Well, we're not going to pay now because of habitability or any number of these issues that they've used for years. How does a landlord put themselves in the best position to prevail when in these type of lawsuits, and you have BASTA or one of these other groups on the other side, basically just trying to drag out the timeline?
Sheer excellence in management. If you are a landlord who cuts corners, who is slow to respond, who fixes things with bubblegum and baling wire, you have a problem, and frankly, you deserve one. If you are rapidly responsive, if you tell people, look, even though you're not paying the rent, we want this place to be right, so if anything's wrong, let me know. If you are forward acting, proactive, immediately responding, and responding with professional licensed plumbers, roofers, electricians, whatever it is that's necessary, if you replace appliances when they need to be replaced, if you do the things that you should do as a landlord that you would do to your own home, then the result will be that habitability claims will fall by the wayside. When we deal with habitability claims by tenants, by BASTA, or by anybody else, very frequently we agree with the tenants that the landlords have done a terrible job. And when we point it out to the landlord, especially if they've used a professional management company that hasn't done the job, they agree with us. The landlords agree with us. We need to take responsibility for that. Good business is always moral, and it's always ethical. And if the behavior of a landlord is not moral or not ethical or not fair, it's not good business. Good business is maintaining your property and making it the nicest property in the neighborhood so that tenants don't just pay the rent, they honor the rent. It's a matter of a landlord doing their job and doing it well. Sheer excellence in management is what the goal should be.
Yeah, about a week ago, I interviewed Bruce Norris, who you know well. He's a part of our educational events. And basically his comment was, slumlords, it's the end of the slumlord, because they're coming for you, and it truly pays in terms of the type of tenant base and rental rates to just be a proactive landlord. And I think that's what you're saying here.
Slumlords should be eliminated, and everyone who doesn't do their job right should lose their job. And if you're a bad landlord, you should get out of the business and get into some business where you can be sloppy. If you take pride in your property, if you treat your tenants like the human beings that they are, if you fulfill your responsibilities, you just make more money. Good business is always moral and always ethical.
As we talk to landlords, I'd say the majority of them are collecting 98% or better on the rents. It's a small fraction that have multiple tenants that have fell behind. And in LA City, because they've put extra protections in place, probably those landlords are feeling this a little bit more, say, than other areas that don't have, say, something aside of the statewide ban on evictions. So given that landlords have had a good experience of collecting rents, their fears of the worst to come never came to pass, people are transacting. And so I want to transition there and discuss here, some of the pitfalls buyers and sellers fall into when they're going through a purchase sale transaction. But I'll start by asking this: since you are litigating between buyer and seller every day, what would you say is the number one issue that gets litigated between buyer and seller? You see it again and again and again.
Non-disclosure. It is where the seller fails to disclose what has been going on with the property. California law says that every seller of real estate must disclose in writing all material defects in the subject property. My suggestion to sellers is disclose all, not just material, facts, not just defects, that might remotely be of interest to the buyer, not just in the subject property. If a seller discloses all facts that might be of remote interest to the buyer, you'll never go wrong. And you would say, well, but I'll sell for less, or it might turn a buyer off. High producers like you, Chris, tell me constantly that proper disclosure doesn't kill sales. It makes sales because buyers are confident that they're getting the whole story rather than something that's not disclosed. My suggestion when you have apartment buildings, apartment properties, is that you deliver to the buyer all of your repair records, all of the invoices, all of the contracts, all of the reports, everything. There is no such thing as over-disclosure. Disclosure is what matters because over 85% of all the lawsuits that are brought against sellers in the state of California after the close of escrow are over property condition, which means you can remove yourself from 85% of the chances of being sued just through proper disclosure. And you need someone like you, Chris, to be able to help people understand how to disclose properly and disclose with confidence.
So, Steve, with respect to disclosure, my understanding is that a buyer has up to 3 years to sue the seller for something that was not disclosed, but not 3 years from the close of escrow, 3 years from the day they figured out that the seller did not disclose. Can you shed some light on that?
Yes, there are two different statute of limitations. One is the one you're talking about, which is by far the more dangerous one, and that is the statute of limitations on a lawsuit for fraud, for non-disclosure. That is 3 years from the time that the buyer discovered or should have discovered it. So you could see a claim, someone saying 14 years later, I just discovered it just now. Well, they have 3 years from the 14th year to sue you for fraud. The other statute of limitations is on written contract, breach of a written contract, and that's 4 years. That would be from the close of escrow. But this 3-year statute for fraud starts when the buyer discovered or should have discovered it. So yes, there's basically no statute of limitations on it. Statutes of limitations are really good for TV shows and movies, but in real life, they're not nearly as clear-cut.
Now, what about this clause that I see people put into contracts, and my understanding is it doesn't have much teeth. You tell me, as is. Either a seller will put they're selling the property in as is condition, or a buyer will put they'll purchase the property in as is condition. Some go as far as buying a property sight unseen. They never even conduct an inspection. As is, does it have any teeth? Can you show the judge, hey, he said as is, why am I being sued?
No, the short answer is no. The slightly longer answer is, oh my goodness, no. As is does nothing for the protection of the seller. All properties, except brand new ones, single family residences that have an implied warranty on them as a matter of law. Outside of that, all transactions in real estate sales are as is. In other words, there's no warranty. But that's not what a seller is really saying when they say, I want to sell as is. What they mean is that the sale price will not be lowered and the seller will not do repairs. That's what it really means. And so what I suggest be done in any counteroffer that a seller is going to give, where you think that the buyer may be thinking, well, I'll come in low and I'll retrade during escrow, I'll ask for big repairs or big adjustments, is you simply say, and you can say this verbally, it's not a contractual issue, you say to the buyer through their agent, the seller is not going to lower the price and is not going to do any repairs. You do your inspections. And if you like what you see, close escrow. And if you don't, cancel escrow, but we're not going to renegotiate. If that message is given strongly and clearly to the buyer, then nothing in writing will add to that. Nothing will help, and it's best not to even put it in. It's also confusing to a seller because a lot of sellers misinterpret as is as meaning they don't have to disclose. Mm-hmm. Seller has to disclose everything always.
Now, what about something that, say, truthfully, the seller didn't have knowledge of? For example, in multifamily, you'll run into properties where every unit has a meter. It has a gas meter, has an electrical meter. So the assumption is, well, these all must be legal units. After all, Edison and the gas company allowed for there to be a meter. And lo and behold, there's a bootleg unit because finally this new buyer does his homework, goes to the city, pulls the building permits or the certificate of occupancies, and hey, there's a bootleg unit here, an illegal unit. And the seller said, oh, I didn't know that. I actually purchased the property thinking it was X number of units. What happens in that situation?
Nothing. The seller has responsibility to disclose everything that the seller knows. If the seller doesn't know, the seller doesn't know. Now, what some dishonest sellers will say is, oh, well, I didn't know. This is where extrinsic evidence comes in. We had a case once where the buyers found that their house was moving down the hill. I went out to the house. I was able to stick my briefcase into a crack in the kitchen wall. It was that big. It was a crack big enough that I could put my briefcase in it. And the sellers said, we didn't know anything about this. We had no idea whatsoever. So our clients, the buyers, called a structural engineer, and the structural engineer came out to the house and looked at the house and turned to the buyers and said to Mr. and Mrs. Buyer, I told you a year ago this was going to happen. Of course, the buyers looked at the structural engineer and said, we weren't here a year ago. And the structural engineer literally said, well, I'm not very good at faces, but I was here and whoever I told, that's what I told them. I said, you were here a year ago? He said, yeah. I said, okay. Do you have a report? He said, sure. And this was years ago. I said, can you have him fax it over? He called his office. They faxed it over. And sure enough, this report addressed to the sellers, told the sellers exactly what was going to happen. And here it was. There was a land movement problem. The house needed to be placed on caissons. It was probably cheaper to tear the whole house down. And as a result, we were able to resolve this case very quickly once we confronted the seller's attorney with the evidence that this had happened. So the idea is if a seller doesn't know, they don't know. They don't have liability. But if a seller lies, they're generally going to get caught. Not always, but generally they're going to get caught. So a seller who is honest and tells everything they know doesn't need to be worried about a legitimate lawsuit being brought against them for non-disclosure because they're not guilty.
Now let's beat up the buyers a little bit here. So let's say now on the buyer's side, something like a loan contingency. They have a loan contingency and their loan contingency, say, is 30 days. Before the 30 days are up, they give a notice that they want to cancel escrow because the loan didn't come through. Do they have to give proof to the other side that the loan they were looking for was not approved, like, the terms they were looking for? Or how does that work out?
Only if the seller challenges it. Because if the seller says, okay, you didn't get your loan and gives back the deposit, then that's the end of it. But if a seller says, I don't believe it, then the burden is going to be on the buyer to be able to demonstrate that they really couldn't get the loan, that they didn't kill the loan themselves just to get out of the deal, that they aren't just saying they didn't get the loan, that really there's some legitimate reason why they didn't get the loan, and that they acted in good faith to go ahead and try to get the loan. So if they didn't apply for the loan or didn't apply on time or they didn't produce their financial statements or what have you, there's a problem there too. There's an implied covenant of good faith and fair dealing in every contract in the state of California. And so the buyer is responsible for acting in good faith. And the courts will decide what's in good faith or not. And this is what gives negotiating power to a seller to try to keep a portion of the deposit or all of the deposit if a buyer has not acted in good faith.
So I'm glad you brought up deposits. So let's jump there. Because the market is competitive, especially now, oftentimes a buyer will put more down than, say, the customary 3% earnest money deposit. Here in California, 3% is about the average, but oftentimes people will pony up 5-10% just so their offer has a little bit of an edge. Now, let's say aside of the increased deposit, they also put terminology in the purchase agreement, the buyer does, stating, or even the seller requests it, but there's terminology that says the buyer's deposit is hereby released to the seller, non-refundable through escrow without any further written instruction. And so then the deposit is released, but down the road, the buyer doesn't perform and they want out. Can the seller go after the entire deposit regardless of the percentage it was when the buyer has released it non-refundable?
Depends on a bunch of things. The main thing is this 4 units or less? Because in California, the limit for liquidated damages to a seller from a buyer who's in breach is 3%. So 4 units or less, 3% of the purchase price or the earnest money deposit, whichever is less. So if it's over 4 units, if it's commercial property or if it's apartment buildings of 5 units or more, then the 3% limit doesn't apply, but you still need a valid liquidated damages clause to be able for a seller to keep that deposit. And the buyer needs to be in breach. So this isn't a buyer who's canceling because they hadn't removed contingencies. It's got to be a buyer who doesn't have any contingencies left to remove and who simply, through no fault of the seller, has failed to close escrow on time.
Now, as part of the due diligence period, you mentioned, of course, you own a couple thousand doors here. So you've been through a transaction or two. So due diligence, when we're representing a seller, sometimes they'll just give us a shoebox of mixed match, some water bills, some electric bills, maybe a tax bill from 2 years ago, right? So you're trying to piece this together. As a buyer, what are you, and again, I know you own some larger stuff, but let's say it's a 10, 20 unit multifamily building. As a buyer, what items are you looking for from the seller in terms of due diligence documentation?
As a buyer, I want 2 things. The first thing I want is everything I can get from the seller and the realtors to disclose to me the condition of the property. So I'm going to look at the written disclosures. If it's 4 units or less, I'm going to look at the real estate transfer disclosure form, the seller property questionnaire, the agent's visual inspection disclosure. I'm going to look at all those documents. And if it is, and then I'm going to look at all those receipts, the shoebox full of receipts. I'm going to figure whatever I can figure. And if I have questions of the seller, I'm going to ask the seller in writing and ask for answers in writing. Those are all the things. And of course, I want an estoppel certificate from the seller. That's what I'm going to want every single time I have rental units, no exceptions, unless the price reflects the risk I'm taking by not getting those. So that's the first thing I want. Here's the second thing I want. I want to do a due diligence investigation that starts with a physical property inspection. Then I'm going to want to go from there and add whatever other experts I need to tell me about the condition of the building. I'm going to want a licensed roofer, a licensed electrician, a licensed plumber, a licensed contractor, a licensed architect, a licensed structural engineer, a licensed soils engineer. Maybe not all of them, maybe none of them, maybe 1 or 2 of them. It depends on the circumstances. Maybe a licensed surveyor. If I'm not concerned about the boundaries, the property boundaries, then I don't need a survey. If there's nothing wrong with the plumbing, I don't need a licensed plumber. But if I have reason to believe that there's a problem with the plumbing or that there's a sewer issue, I'm going to want to get the expert to come out and do this. So 2 things. 1, you want everything you can get from the seller and the realtors. And then 2, you want to figure you haven't gotten the full story because it isn't available to you for one reason or another, and you're going to do your own investigation. I see so many buyers reluctant to spend a few $1,000s on inspections when they're buying a property that's going to cost them $1 million or $5 million or $10 million, and they don't spend the money. And then they have problems later. And so to me, one of the things when we buy a property, we are perfectly willing to do all of that due diligence and then cancel the sale if it doesn't work for us. If there's something wrong with the building or if something is revealed about the rents or the bookkeeping or whatever it is, we'll eat that cost and we'll eat it every single time because you never lose money on a deal you don't buy.
Right.
And if you go buy something without due diligence, you've kind of earned the problem. So due diligence is the name of the game when you're a buyer. what you can get from the seller, but what you get on your own is what really counts.
Now, what if you have two able, willing parties, buyer and seller, both want to do the deal, and there's a cloud on title? Let's say there's a previous lien from years ago and we don't have a reconveyance, or the seller has a tax issue and the IRS has put a ding on the property title. And the seller just does not have a way to, maybe that tax bill is too high, they don't have the money, there's not enough proceeds in the sale, or what have you. The seller cannot clear the cloud. What's their responsibility here if the buyer says, look, I'm going to push the issue, we have an agreement, I want the property?
Seller's got a problem because the seller is going to need to clear title somehow, someday anyway. And that seller is in a contract with the buyer. The buyer has a right to demand performance. So the advice to the buyer would be, if you want this property, you go ahead and sue for specific performance. You record a lis pendens, which stops the seller from selling to anybody else or from refinancing. And you pursue it and you insist on a court order ordering the seller to clear title. And if it takes 2 or 3 years to do it, well, that buyer is going to get to buy the property at today's contract price in 2 or 3 years. Disaster for the seller. The buyer is going to get all their attorney's fees paid by the seller. Disaster for the seller. The buyer is going to be able to force the seller to buy down the interest rate if interest rates have gone up. Disaster for the seller. So there's a disaster. The advice I would give to the seller is, you have a problem with title, you're going to have to get it cleared up anyway. Why don't we see if we can get it cleared up quickly enough that we can still sell to the buyer in a reasonable period of time? And if not, you better pay this buyer to walk away so that you can then take your time, fix the title problem, and have marketable, insurable title for the next buyer that comes along. But don't let this buyer just sit here and rack up fees and sue you, because it will be very painful later. And of course, there are lots of alternatives. You can negotiate with the buyer. There are many buyers who won't sue. They'll just walk away anyway. There you can get out for a small amount of money. All hope is not lost unless the seller just folds their arms and says, oh, I don't have to sue. I don't have to sell to you. They do. They have to sell.
So I imagine that goes for just about anything. Let's say, for example, a seller wants to complete a 1031 exchange and they're into the escrow period now. They realize, my realtor's not being proactive, or I can't find a property. I haven't found a property and I'm fearful to close escrow. So you know what? I'm just not going to close because I don't have anything to buy. I imagine and unless it was a contingency, unless the 1031 exchange, the identifying of a property was a contingency, I imagine same thing here. They're going to have to sell one way or the other.
Well, the seller is going to get a new nickname, and the nickname will be Defendant. The result will be a buyer who's going to be in a position to sue, again, for specific performance or record a lis pendens. And so, again, the seller might decide, okay, I want to get out of this, and might need to negotiate with the buyer, but the seller needs to understand that the buyer has an enormous amount of power here for all the reasons, same problems you had in the last example. And as a result, the seller needs to come and act very quickly and affirmatively to solve this problem with the buyer, to buy an extension, to do whatever they have to do to avoid the fight that the seller will very likely lose.
Now, all these various issues, essentially, if there's an issue between buyer and seller, more than likely it's going to end up in a mediation. Luckily, I've only ever been a part of one mediation, and actually you were the attorney there. This 15 years ago, and it was a sight to behold, to watch you in action. But mediation, if no one's ever been there, and say right now there's something pending where they may find themselves in mediation, what's to be anticipated that takes place there?
So first of all, mediation is not arbitration. Arbitration is a full binding trial where a decision is made and there's no appeal. Mediation is not a trial. That would be in front of a judge or a judge and jury where there's a final decision. You might have a right to appeal, but I wouldn't count on winning an appeal. Less than 8% of all appeals are won by the person who is appealing. Mediation is a settlement meeting. Mediation is a settlement meeting that's presided over by a mediator who has no power and who does not make a decision. Before COVID, and I'm sure coming up now, I had approximately 55 to 65 mediations a year. Put another way, more than one a week. And out of all of those, we settle almost every single one of them because mediation is a magnificent, dramatically less expensive way to solve problems than arbitration or a trial. Much better than a lawsuit. What it does is in the right hands, with the right mediator and the right lawyers, it gives the parties a chance to air their grievances and to be heard and to hear the other side and understand, and then to resolve the issue. Trials and arbitrations resolve issues based on law and facts. Mediation resolves issues based upon risk and motivation. And as a result, people coming into a mediation, if they come in with the right attitude, can almost always solve a problem. When a mediation fails, something went wrong. In the right hands, a mediation should solve problems. But it's got to be done in kind of an unusual way. Normal mediations are handled all in separate rooms with a mediator going back and forth. I prefer a joint session because I find it to be overwhelmingly powerful. It gets a great deal done. Yes, people are running high blood pressure while they're doing it, and I'm sure their heart rates are up too, but the problems typically resolve, and we've resolved some tremendous cases as well as many medium-sized and small ones through a mediation process, which instead of dragging on for years, typically is done in a day. And instead of costing tens or hundreds of thousands of dollars in legal fees, it costs a few $1,000s. And instead of having enormous risk, it reduces risk to zero because you resolve things. So what you should expect in a mediation is to follow Stephen Covey's rule as he expressed it in the 7 Habits of Highly Effective People. Seek first to understand and only then to be understood. So you'll be a good listener in mediation. Properly orchestrated, a mediation is exactly where you want to end up instead of a lawsuit or an arbitration when you have a difficult dispute.
So somebody thinking, well, my attorney, he's a hard-nosed son of a so-and-so. He's the guy I want. Maybe not so, because he might not have the right attitude for mediation. He might be great in trial, but maybe not in mediation.
I remember before I was a lawyer, when I was running a business and we had a lawyer, I remember, and I was in my late teens running this business. And I remember looking at our lawyer and thinking, he must be really good. He looks like he has a headache all the time, and he looks like he's angry all the time. And I thought he was a great lawyer. What I learned when I became a lawyer is it's kind of the opposite. If you get along with the other side, if you can communicate, if you can be a professional, then it becomes true that just because you see the teeth of the tiger, it does not mean that he is smiling at you. One of the best ways to solve a problem is to open lines of communication, allow people to feel heard, get your point across to be sure, but you do it in a way that you can be heard, where the other side can understand, and then you figure out what they want and you help them get what they want while you're getting what you want. It is a process. It is a negotiation. It's a great deal of fun. And clients who hate this sort of thing come out of it usually saying, Chris, what you said, which is it's fun. It's interesting to see a problem getting solved. I firmly believe that if we could teach all of the people in Congress to mediate, we'd probably get more things done.
Yeah, you think, right? Now, you mentioned arbitration. So arbitration in the CAR form, the RIPA, that we use for multifamily transactions, says in big, bold letters that it is binding. Yet, my understanding is maybe not so fast, because if you go to arbitration and let's say the seller's found at fault or they're supposed to pay a judgment, the seller can basically, or either party could say, depending on the case, no, I don't take that. I want a jury trial. Is that true?
No, not at all. Not at all. Once you are properly submitted to arbitration, and the CAR forms, the California Association of Realtor forms to which you referred will do that, the arbitration is binding. And when the arbitral award comes out from the arbitrator, it's binding. There's no right of appeal. The exception being if you can prove that the arbitrator was corrupt or insane. So if you can show evidence of bribery, like canceled checks, or if you can show a finding of a psychiatrist that the arbitrator was psychotic at the time, you're not going to have that. I've never heard of it happening. I'm sure it has somewhere, but I've never heard of it happening. Outside of that, it's binding. And if the party who loses doesn't do what it says in the arbitration, if they don't pay up, then you simply apply to the Los Angeles Superior Court or the San Bernardino, whatever county you're in, Superior Court, and get a court order turning that arbitral award into a judgment. And then you have all the power of the court to seize funds and force performance. So no, arbitration is binding, and it's binding.
Well, and the hope is that, everybody plays fair, right? Buyer, seller, that we have two willing parties. I've now sold over 300 multifamily buildings on behalf of clients. You've been in a number of transactions. That's the hope. But what is your take on signing the arbitration clause? Because that is a choice. Either buyer or seller does not have to sign that paragraph. How do you look at that as when you're involved as the investor yourself?
It took me a long time to figure this out. I've been practicing law for 43 years, and it took me literally the first decade before I could pick up a pattern, because I asked a lot of lawyers about this question. And what I found was that the lawyers who said, I would never sign an arbitration clause, they had gotten their heads handed to them by an arbitrator. So they concluded that was the arbitrator's or the system's fault. So I don't think there's a rule of thumb. I think you can get a very fair trial in front of a judge or in front of a judge and jury or in front of an arbitrator. I think you can also get a terrible trial in front of any of the three. And so my view is that I would never lose a deal over an arbitration clause. If the other side insists on arbitration or no arbitration, I'd say fine. If you gave me my choice, I would probably say sign arbitration rather than not, because arbitration tends to be far more cost effective and far more controllable. If you have a private arbitration with a private arbitrator, that arbitrator works for you, for the various parties. And if they say it's going to start at 9 o'clock in the morning and go to 5, you're going to get 8 full hours, and you'll decide we'll take a lunch break here or there. And that gets negotiated very comfortably, not constrained by systems. It's just what the arbitrator agrees to do in consultation with the lawyers. And that's usually highly accommodative so that things can be convenient. Also, when you have a date for arbitration, that's the day your trial starts. You go to court with a court date, it might get postponed 5 times. So you spend the money to get geared up for trial, then you don't have a trial, then you gear up for trial again, costs much more. The only thing that costs more about arbitration is the judges are paid by the county. The arbitrator is paid by the parties. And so that part is more expensive, but on balance, it's cheaper than going to a jury trial for all the reasons I just said.
Now, Steve, you and I, Bruce Norris, Michael Brennan, Steve Paul, Gil Figueroa, we'll be together in June for our apartment owners educational webinar. It used to be a live luncheon. Hopefully soon it'll be live luncheon again, but webinar, really to prepare the landlords for the 3rd and 4th quarter of this year. Of course, there's a lot of different things up in the air. The political climate has changed in the country. We have a governor that potentially is looking at a recall. You mentioned earlier the economy, the financial markets. There's a lot of things that we're going to be discussing. How do all these various things impact a landlord? Between now and then, when we see each other, what last suggestion can you give landlords so that they do profit in multifamily and they continue to move their financial legacy forward for them and their heirs in investment real estate?
The only regret that people who have invested in real estate over a period of decades have is they say, I wish I'd bought more. And so my encouragement is, within the rules of common sense and safety, don't get over leveraged, don't get in a position where you can't hold on during the tough times. But given that, buy, own, hold, then buy more and refinance to buy more, and do things, not too much leverage, but enough leverage so you have the ideal leverage where you don't have too much risk, but you have maximum cash. Manage the properties with sheer excellence. Take your tenants seriously, respond quickly and effectively. Don't try to save money by cutting corners on maintenance and management. I think those are the top two.
All right, Steve. Well, thank you, sir. It's always a pleasure to have you. I know the landlords greatly appreciate the time that you give to our show. And I wish you and your family all the best here until we see each other in June.
Thank you very much. I'm looking forward to it, Chris. I always appreciate it.
All right. Thank you, sir. Well, there you go. There's 4 decades of being a real estate litigator representing landlords like you. Steve has seen all sorts of cases. And in that same amount of time, he's also owned investment real estate. I was once told that if you want to find a financial planner, find the guy who's already retired, right? Because he took his own advice and it worked. Well, if you want to take advice from an accountant, an attorney, somebody giving advice in terms of moving and selling properties, you want to deal with those that actually have skin in the game, that are involved in the day-to-day management of properties, that have the practical knowledge of what is it to be a landlord. I hope you found it informative. I hope Steve's insights help you in the day-to-day management of your properties. Be sure to give this video a like, subscribe to our YouTube channel, and turn on notifications so that you receive these videos as we release them. And probably more importantly, share a comment. Is this information helping you? What questions do you have? Who should we go out into the market and interview so that it would help you push your financial legacy further, faster? Chris German from The Apartment Dealer. And as always, wishing you positive cash flow, tenants who behave, and much protection from Uncle Sam. Till next time.